Hi, this is Dan Garrison with Fresh Start Funding.
And I'm Matt Hartley, also with Fresh Start Funding.
Welcome to our webinar today, which is about the ins and outs of offering a zero-down option to your Chapter 7 clients. The webinar is probably going to be about 45 minutes long. Those of you who are familiar with Zoom know all the tricks, but let me just kind of walk through a couple of points with you to make sure that we're on the same page. We are recording this. It will be available to rewatch at some point. It'll take a few days probably to clean it up. We will be taking questions during the webinar, but we typically do those at the end of the presentation. And so if you go to the toolbar at the bottom of Zoom, you will see a Q&A icon. You can go ahead and type in those questions whenever they happen to pop into your head, and then we'll take a look at that list of questions at the end of the webinar and do our best to get through all of those things. Maybe we can start out by just telling you a little bit more about who we are. It's always helpful to know a little bit about the folks who are purporting to teach you something. Fresh Start Funding, as most of you know, is a company that's involved in offering financing, payment management, credit reporting, and best practice support for attorneys that want to offer post-petition payment terms to their clients. And Matt and I are both attorneys. Matt Hartley has been practicing for about 27 years at this point.
It's kind of scary to add up the years, but yeah.
It creeps up on all of us. Matt went to a top 10 law school. He started out his career in big law, was a partner with an international law firm for quite a while doing transactional work. When the entrepreneurial bug hit him, he went into private lending very successfully for a number of years, and then started doing some consulting in the restructuring and turnaround space before several years ago recognizing the opportunity that consumer bankruptcy presented. Matt started a consumer bankruptcy firm here in Arizona where we're located, which he very quickly grew to be the largest Chapter 7 filer in the state of Arizona. And it's along the way that he learned about bifurcation and the way that you can legally and ethically offer post-petition payment terms to your clients. And he and I got together after knowing each other for about 20 years to start this company a couple of years ago.
Yeah, exactly. And Dan's background is similar to mine. He also went into the big firms first and was a partner at maybe two firms?
Yeah, a couple of large firms.
Large firms. His practice has been focused always on bankruptcy, but more on the commercial side. And he's done a lot of writing and speaking nationally. And is well respected across the country for his bankruptcy work and what he's done to help raise the bar for all attorneys across the country.
So what we're going to talk about today is really more of a nuts and bolts kind of presentation around bifurcation and really how it works in a Chapter 7 practice from a day-to-day perspective in terms of documents and process flows. We'll also talk about some of the ethical pitfalls that are out there that you need to avoid and that we work really hard to help our clients to avoid. So let's talk just a little bit about what the agenda is going to be for today. And I'm going to jump onto our PowerPoint presentation here, and I would ask you guys to be patient as we kind of go back and forth between here because I'm trying to multitask a little bit. So what we're going to talk about today is, as I said, really the nuts and bolts, and we've kind of put this into three buckets. We're going to talk about the ethical pitfalls that exist out there for attorneys that want to offer post-petition payment terms to their clients. We're going to talk quite a bit about managing the internal flow of your practice and how things are different when you're offering post-petition payment terms, and particularly where you're offering what's come to be called zero-down terms, or the idea of getting a case filed quickly without the client having to come out of pocket. And Matt really is the expert here. He was running a practice that filed as many as 100 cases or more a month, and a large percentage of them were zero-down cases.
Now, if my staff from my old firm were here, though, they would say they would take all credit for that, and they're probably correct. But they did share some knowledge with me that I'll share with you guys now.
Then we'll kind of wind up the presentation today talking about some concrete steps to get started if this is something that you're interested in doing in your practice. All right, so let's start out talking about ethical pitfalls to avoid. And this is really kind of crucial because, as I'm sure many of you who are on the webinar today know, there have been attorneys over the last several years who have tried to offer post-petition payment terms to their clients who've gotten into trouble because they've made some mistakes. And in fact, it turns out those mistakes are of very common types. We can kind of throw them into buckets and describe them to you really simply. And they're also pretty easy to avoid. So we want to talk a little bit about that. And first has to do with the most basic idea of bifurcation.
Yeah, using two fee agreements. So the whole basis of collecting fees post-petition and how it's different from having to get paid up front is that you're creating a post-petition obligation that's not discharged or subject to the stay. And so to do that, you have two fee agreements with your clients. One that they sign with you initially so you can file the case, and a second that they sign after the case has been filed that then deals with all the post-petition services that you're going to be providing and also provides for the post-petition payments that you'll be collecting.
So, this is a relatively new concept for some people around the country, and it's surprising to me because there are a lot of districts where this is pretty pervasive and it's very well accepted. But there are certain places in the country where it's still a rather novel concept. But notwithstanding that, there's actually 25 years of case law out there that has kind of walked through the evolution of what we call the modern practice of bifurcation. The cases started out, not surprisingly, in the bankruptcy courts in just a few states in the mid-90s. And their attorneys played around with different ways of trying to allow their clients to pay post-petition. I guess we should start out by just kind of stating the obvious. There's a large unmet need out there in terms of debtors not having the ability to pay attorney's fees up front. And all of us who've practiced in consumer bankruptcy know this, all of you know this, that a large percentage of the debtors who show up at your door simply don't have a way to come up with the money to prepay your attorney fee. And so it puts them in, a not attractive position of either having to forego the opportunity to file bankruptcy or to try and do it on their own. And we all know that the success rate of getting to a discharge in bankruptcy is significantly lower if you don't have an attorney, whereas where you're represented, there's about 100% chance of getting a discharge. Or, a lot of us, for lack of a better solution, have probably put people on what we call layaway plans in the past, where folks make payments pre-petition while the creditors are still chasing them. Maybe they're fighting garnishments, who knows, but they're definitely not in a good place to be making payments. Attorneys started playing around with this in the mid-90s with mixed success. In the late 90s, there was a case that came out of the Ninth Circuit Court of Appeals called Hines, and another one that followed pretty closely thereafter, that approved the idea that you don't really earn the fees until you do the work, and so you can absolutely collect fees for post-petition work, but not on a contractual theory. So in that case, the attorney had a single pre-petition agreement, and the court said, look, that agreement is discharged and it's unenforceable, and you can't chase somebody under the contract terms because of the stay. But what you can do is you can raise a quantum merit or an unjust enrichment, an equitable claim for the reasonable value of the services that you provide. And that technically remains good law in the Ninth Circuit, although candidly, it's been criticized pretty roundly across the country as sort of a make-do solution for a problem that we all recognize. Over the next several years, a number of attorneys, in different districts tried other methods of getting paid by taking post-dated checks or by trying to separate the services and the fees in a single agreement, notwithstanding the fact that that agreement is still a pre-petition agreement that gets discharged. And from about 2005 to 2012, there's a hodgepodge of cases where attorneys have tried different things. Long about 2012, the case law started to converge into what we think of as the modern practice of bifurcation now, with a case out of Florida called Walton that involved the Clark and Washington firm, a case out of Detroit called Slab Inc. Those two cases and some of their progeny really kind of solidified the idea that if you bifurcate the engagement into two separate agreements, the post-petition agreement is not subject to the stay and is not subject to the discharge. And we'll talk about some of the considerations that the courts walk through in terms of these ethical pitfalls. But I guess what we want to convey here is that there has been a pretty steady evolution of this practice. And for the last several years now, there has been, a consensus in the case law. So the cases that have followed after those 2012 decisions have often pointed out where attorneys have made the mistakes that we're going to talk to you about, but have nonetheless observed that bifurcation itself technically is legal and ethical. There was a decision that came out of Utah just this last April called Hazlitt that has really gotten a lot of national buzz, so much so that even the director of the United States Trustee Program out of DC, Clifford White, commented on this just in August in front of the National Association of Bankruptcy Trustees annual conference. that this was a particularly well-reasoned decision, and he commended it to the U.S. trustee program in the bar. And in that Hazlitt decision, the court really came to an unqualified conclusion that when done correctly, bifurcation is legal and ethical and does solve the problem that we started out talking about, which is debtors having access to an attorney and access to a fresh start.
One of the best parts, I think, of the Hazlitt decision, besides I really like the positive decision, is that really went through all the issues that have been raised over the years. It's a 27-page opinion, which is, especially for a bankruptcy court, is a very large opinion. But it really went through all the issues, analyzed them, and came to the conclusions that we agree with and the case law agrees with, and that you can do this. So I highly recommend you read the case if you haven't.
Yeah, and it's interesting. We've been publishing nationally and speaking on this topic for a while, and we sort of painted a roadmap in an article that was published in the ABI Journal last June. And it was gratifying to us that the first decision that came out on bifurcation after we published that article tracked very closely the analysis that we advocated for everybody last June when we published our first article on the topic. But I think it just goes to show that there is a developing consensus around this. So let's jump back into the PowerPoint. And Matt already kind of covered the two additional points, which is that essentially you need to be dividing your work into two agreements, a pre-petition agreement for pre-petition work and a second signed post-petition. So what does that mean in terms of the actual work, Matt?
Yeah, so what I think is very important when you have two agreements is that you set forth exactly what you're going to do pre-petition, exactly what you're going to do post-petition. And in a typical zero down, low down case, most attorneys will file just the minimum documents needed to start the case. And in most places they call it a skeleton, emergency, it's not a rush case. But basically the code is very clear on the documents you have to file to start a case. And it's also very clear that you have 14 days to file the statements and schedules. And that's the second important part of this, is that those statements and schedules, you're not going to prepare them until after the case has been filed, because that then creates post-petition work that you can collect post-petition fees for.
I think it's important to note, though, technically bifurcation just means splitting your engagement into two pieces. And so certainly there are attorneys across the country that choose to still split the case differently. They'll file schedules and statements with the petition. And as we'll talk about when we get to fees, what that does is it just impacts the allocation of your fees between the pre-petition and post-petition work. But if you're going to offer a true zero-down solution to clients, it's important to maintain a viable practice that you do as much work as you can post-petition.
But one thing that's on here, we get asked this question all the time, is attorneys say, well, if I'm doing the skeleton and doing the statements and schedules post-petition, what about the required due inquiry, due diligence that you have to do as a bankruptcy attorney before you file a case? And the answer to that is very clear and simple, is you still do it. You still collect all their documents, you still pull their credit report, you still review everything, you hopefully have a nice and clean client intake questionnaire where they can answer lots of questions that you can then dive into when you do your initial consultation. But you absolutely still do all your work up front before you file the case, because you never want to file a case not knowing about the landmines that might be out there, or even not even knowing if they passed the means test. So you have to do your work up front.
And just as you have to clearly divide the work in between the two agreements, you have to do the same thing with the fees too.
Yeah, for sure. So again, the two agreements, you're very clear in the agreements about the fees you're charging for your pre-petition work and your post-petition work. And really your pre-petition agreement, even though it doesn't bind the debtor or you for the post-petition work, it should still disclose to your client what it's going to cost to have you finish the case. So it should tell them exactly what the fees are for that.
Yeah, and we'll talk about this when we get into particular tips about the engagement agreements themselves. But really, the key here is that you have to clearly split the work and clearly split the fee between the two agreements. And we'll talk about a tool that we use to help attorneys figure out what is not only a reasonable overall fee, but what is that reasonable split between the pre and post petition work. Okay, so another one of our favorite topics is disclosure, and I will tell you that of the ethical pitfalls to avoid, this is the one that almost always trips people up who get into trouble around bifurcation. In fact, I would go out on a limb and say that every single case where an attorney has gotten into some sort of trouble around offering post-petition payment terms, it has involved disclosure issues, either with the client or with the court.
Yep. So with client disclosures, you have to make sure that you're clearly describing what their options are for paying it. And what that really means for most attorneys, if they offer post-petition payment terms, there's usually additional costs to the attorney, there's additional risk to the attorney. But at the end of the day, attorneys will typically give two options to their client. One is if they pay up front. The second is if they want to get filed right away and make payments for 12 months after the case has been filed. And it's really up to the client to choose what's better for them, but it is best practice to give them the two options so that they can make that decision.
You know, and we have another tool that we provide to attorneys that's very simple but very powerful. And it's a one-page sheet where basically, you know, on one side of the paper, they present the prepaid option and what the costs will be there. And on the other side of the sheet, they put the, you know, pay over time option. And if it's a different cost, they disclose that. And then they often break it down in terms of what that would be in a monthly or a bi-monthly or a weekly payment, so that it's really clear to the client the financial decision that they're making. Yeah. The case law, you know, particularly the more recent cases, have noted that it's a very powerful piece of evidence about informed consent if attorneys can show that they provided a choice to the client, and without any sort of encouragement or advice or duress, you know, the client chooses the post-petition payment option over the prepaid option, even where there's a fairly significant difference in fees. And on that score, I will tell you the Hazlitt decision, you know, has a great discussion, because there the client chose to hire an attorney who had a post-petition payment option that was almost twice as expensive as another attorney offered to charge in a prepaid retainer to represent them in the case. And the court went through the lodestar analysis, which we'll talk about in a few minutes here, and came to the conclusion that where the client clearly understood the two options and chose of their own free will, you know, to enter into the post-petition payment option, that it was informed consent. Yep.
Again, disclosures, we've mentioned this, but you know, it's just very important to describe the two agreement structure, what it means, you know, what are the rights of the debtor, you know, do they have to sign the second agreement, do they have options, and what you disclose to them is that they have options. They can either, you know, sign the second agreement to have you do it, they can hire a different attorney to help them out, or they can go pro se. But in most cases, the debtor will just sign the second agreement because they hired you the first time. Why wouldn't they hire you the second time?
Yeah, and we'll get into that a little bit when we talk about so-called unbundling and local rules around limited scope representations, and making it clear to the client that you're ready, willing, and able to represent them for the entire case. Yeah. And perhaps even having them acknowledge that while they're entering into this two agreement structure, in order to be able to make post-petition payments, that they're entering into it very much with the intention that they're going to have you represent them for the whole case becomes important. And then, as I said, you know, we need to talk about local rules, and we're developing some specific tools in different jurisdictions to deal with local limited scope representation rules that are, you know, somewhat more specific than other districts have. But your agreements need to disclose those kinds of things up front. So the other big pitfall we've already alluded to is what you tell the court. And everybody's familiar, I think, with the Rule 2016B disclosure, the Form B 2030. I would say most folks are not terribly familiar with some of the history and the nuts and bolts around it, but Form B 2030 is what they call a director's form. It's not an official form in bankruptcy, and you can modify it so that you can provide thorough disclosure. And the second article that we published in the ABI Journal just this last July really goes into this in some depth and explains the disclosures that we recommend that attorneys make who are offering post-petition payment terms to clients. And even more particularly, attorneys who are working with a company like ours that helps them with financing and payment management. So that is the key disclosure to the court.
Yeah, and there's Schedule J. So Schedule J is where you'll disclose the monthly or weekly payment. It has to be set into monthly terms, of course, for Schedule J. That's where you disclose the payment that the debtor is going to be making. And we talk about this all the time, but you know, really, Schedule J is not designed to include post-petition obligations. Like if they were to buy a car after the case was filed, you wouldn't put the car payment on Schedule J. And really, the same should apply to the post-petition fee agreement that a debtor enters into with an attorney. That payment doesn't have to be on Schedule J. However, Universally, trustees, HAPs, holders, they want to see it on Schedule J. So we advise all of our clients to put that payment on Schedule J. If there's ever a trustee someday that says it shouldn't be on there because they agree with the legal analysis on it, then you can always take it off. But I highly recommend you put it on Schedule J because it is an issue that's been raised by some of the trustees.
And the last thing, and this isn't a difference really with bifurcation versus, a traditional prepaid structure, but obviously whatever you do collect up front from your client also needs to be disclosed on your schedule or your statement of financial affairs. And in a true zero down practice, this is sort of the key distinction. There isn't anything paid up front. And technically at the time you file the petition, there isn't anything owed because you've not yet entered into the post-petition engagement agreement. And kind of reflecting back on the Form B-2030, we provide a template for that reflects really the best practices approach to disclosure. But in a nutshell, it involves clearly disclosing what was paid pre and what will be paid post-petition. We have specific language describing the bifurcated nature of the agreement and what has been denominated a pre-petition service and a post-petition service. And then we have disclosure language around the use of fresh start funding or any third-party financing source that involves payment management too. And we're happy to share those with you. At the end of the webinar, we'll talk about how you can get access to Fresh Start University, which is our library of forms and information that will give you some of the specific language and so forth. But for clients that work with us, we actually help them get those implemented into their practice, and we actually do a little bit of quality assurance checking on it too.
Yeah, and one last thing on the Form B-2030 is that is one of the forms that you're not required to file it with the petition, and we actually say you should not file it until after that post-petition fee agreement has been signed. Because if you file it before the post-petition fee agreement has been signed, you really shouldn't even disclose any payment obligations because they don't exist. And it would require you to do an amended version anyway. So you should hold that back and just file with the rest of the statements and schedules, after that post-petition fee agreement signed.
Now, I will tell you though, we've looked at some local rules, and I'll just use it for example here. Colorado has some very specific local rules around this, and they actually do require Rule 2016B disclosure to be made with the petition. Yeah. And so there you do have to two-step it, and you have to disclose what, if anything, you were paid pre-petition, and then you're going to have to file an amended disclosure at the same time that you file your schedules and statements that reflects the terms of the post-petition agreement. So there are limited jurisdictions that we can alert you about as appropriate where the two-step process is going to be required. And hopefully as this becomes better understood across the country, some of these local rules will adapt to the practice. Okay, so the next topic on ethical pitfalls is one that's getting a lot of discussion right now, largely because I think the question of whether bifurcation is allowed has been answered. And so what now is happening is that U.S. trustees and judges are focusing on how bifurcation is being practiced. And one of the things that remains a hot button issue is reasonableness of your fees. And the reason this becomes a big part of the discussion is because, as Matt noted, most of the attorneys who offer post-petition payment terms to clients charge sometimes a small amount and sometimes a rather large amount more for the post-petition payment terms. We're actually working on an article right now that we're going to submit again to the ABI Journal on this topic, but we've also done quite a bit of briefing on this issue across the country as we've been working with attorneys who've had questions raised. The first thing that I would say about this is that the common and I think easy thing to do is to compare what someone charges for a prepaid engagement to what they are able to charge for post-petition payment terms. And that just simply is not the legal analysis. The case law is very clear is supposed to be applied to reasonableness. Yeah. In fact, the test that is required is called the Lodestar analysis. And Lodestar is actually a test that is uniform throughout the federal system. So in any litigation where there's going to be any shifting of fee responsibility, courts look at the Lodestar analysis. And it's very explicitly adopted in bankruptcy too. Lodestar basically involves two simple things. What's a reasonable amount of time to do some service that provides value to your client or value to the estate? And what's a reasonable hourly fee for that service? And I'm going to get a little philosophical here about this. There are very good arguments that the environment for prepaid fees have become so commoditized across the country that people are simply not getting a reasonable value when they charge a flat rate. And we know this because if you actually take a typical flat fee and you break it down in terms of its hourly value, we daily talk to attorneys who are getting $250, $300, $350 an hour for non-flat fee bankruptcy work or other consumer law work. And they're getting $1,100 for a Chapter 7. And when you really break it down for them, they realize that they're getting the equivalent of $75 or $80 an hour for Chapter 7 work. And so, the idea of offering post-petition payment terms is powerful because it takes the conversation away from, the debtor having to come up with a big chunk of money at their point of highest financial distress, and it converts it into easy payments for them, which then in turn liberates attorneys to get a reasonable fee for Chapter 7 work that they're doing. And so it's not unusual in our experience for attorneys who are, in price wars and that so-called race to the bottom in their particular market to be able to suddenly charge significantly more for the fees. What we recommend that attorneys do involves a tool that we've developed that basically lays out the typical services that you may have to perform in a Chapter 7 case and assigns an hourly value to those services, whether it's your time as the attorney or your staff or your paraprofessional's time. And then you put your normal billable hour rate or a reasonable billable hour rate if you're not typically charging hourly. And it spits out what the value of the Chapter 7 engagement is. But more particularly, it divides it into these two buckets of pre-petition and post-petition.
Yeah, it's really an insightful tool. I remember the first time I did it, I was really surprised at how little so many attorneys, including myself, used to get for their fees. Because Dan's right, Dan saying $70 or $75, I felt like it was more like 50 or something less per hour. But so this tool, and again, it's something we'll share it with you. And you can change, the time you spend on different tasks, change the tasks, but it's a real good tool to help you start at least doing your analysis of what's a reasonable overall fee for a Chapter 7 bankruptcy.
Now, I also want to be plain spoken about the fact that part of the reason that attorneys often charge more for post-petition payment terms is that if they're working with a company that's providing financing and payment management, there's generally a cost associated with that. And so they're trying to make it an economically neutral proposition to either offer a prepaid engagement to their client or to offer payment terms so that really they don't have a dog in the fight. They're indifferent, really, to which the client chooses, which is the best possible scenario. Mm-hmm. And the ABA has actually issued a formal opinion on this topic this last year that says very clearly that under the model rules, which virtually every state has adopted with very little changes, you can pass on the cost of financing to a client with adequate disclosure. So as long as you're clear about the fact that part of the reason the fee is higher is that there is an out-of-pocket cost to you for the financing, that it's okay to do that. Now, the big proviso is that the overall fee, including the additional charge for the financing, still has to be a reasonable fee for the services. But that's where we get back to the lodestar analysis and looking at what a reasonable fee is for Chapter 7. And in most jurisdictions, again, if you're talking about a reasonable hourly rate of $250, $300 an hour, it's an eye-opening exercise to actually break down what the value of a Chapter 7 case is. Most attorneys, when they go through that exercise, find that our tool spits out a number north of $3,000, which initially seems shocking to them, but then when they really think about the value of their time, it's defensible. And oftentimes they'll back off from that number a bit because a lot of the services that are in the tool are not services that you'll necessarily have to provide in every case. And so there's some, moderation of that number to set, the prepaid fee that you're going to charge for an installment agreement.
Yep.
So let's jump back in and we're going to move on to the next topic, which is
drum roll,
please. Here we go. Pointers for fee agreements.
Yep. Yeah, so not really in particular order, I guess, here, but the first thing, and where attorneys have gotten themselves in trouble, and this is particularly an issue if you have unbundling rules in your jurisdiction. What some attorneys have done is that they have in their fee agreement that if the client does not sign the second agreement, that the client agrees that the attorney can withdraw. But it creates problems in a couple of fronts. One is with some of the unbundling rules, you actually have to be committed to perform all the basic services. You can't just have the client agree to let you out. But more importantly, the reality of how it works in bankruptcy is that all you can do is you can't just withdraw. You have to file a motion with the court and get the court's approval to withdraw. Until the court actually grants that order, you're in that case. So you're doing all the work that's required in that case until the court lets you out. To me, it's not a big deal. That's just the way it works. But some attorneys have thought they were benefiting themselves by having this agreement to withdraw in their agreement, and it came back to bite them.
Yeah, and there have been a couple of settlements with U.S. trustees' offices across the country where this particular practice was called out as a problem, and the attorney ultimately agreed that, yes, they shouldn't have done that. And it's been at least part of the picture of why they got into trouble. So.
Yep. Yeah, another thing we recommend when you're doing you're collecting fees post-petition is that you don't exclude some services that maybe were either excluded, or if weren't excluded, at least had an additional fee that had to be paid by the client for you to perform it. And reaffirmations are kind of a classic. And in some places, you are required to represent your client in any reaffirmations. In some districts, attorneys are able to carve them out. But even where they're obligated to do it, many attorneys will charge an additional fee for a reaffirmation agreement. And what we recommend is go ahead and just include the reaffirmations in all your agreements for all your debtors. And in some cases you won't do it, and in some cases you might have 3 or 4 reaffirmations. But just include it in your services, just so it's a value add to help also justify the post-petition fees.
Yeah, I guess the practical consideration here is that when you're charging a prepaid retainer, and you're hitting that client up for a lot of money before they can get relief in the bankruptcy case, first of all, you're competing almost solely on price. So you want to be out there advertising as low a price as possible to attract clients. But you're also trying to make the basic engagement as affordable for the client as you can, because they struggle to come up with the money. And so it's very common to kind of carve off as much as you can from the basic engagement and treat them as add-ons. And here, the dynamic ought to be different. If you're going to charge significantly more for post-petition payment terms, then you want to pack as much value or potential value into that engagement as you can as a way to justify the reasonability of your fee. And it becomes almost like a dollar cost averaging kind of a situation where, as Matt said, you won't have to do some of these things in every case, but if you've priced your fee reasonably and thoughtfully, you're going to be in at least as good a position, if not better, and probably better, by being able to offer the post-petition payment terms. So it makes sense to offer more value to the client.
Also, make sure you always include the Section 528 disclosure, and that's just the disclosure that you're technically a debt relief agency. Put that in your fee agreement, put it on your website, for sure put on any advertising materials you send out. It's just important, and again, because we've seen attorneys get in trouble for this, even though it probably seemed unimportant to some of those attorneys.
And then this last thing, I will tell you, this ends up feeling a bit artificial, but there's been case law out there that's called this out as being important, and that is to just sort of understand and acknowledge the fact that you're technically in a conflicted position when you ask a client to, enter into an agreement, particularly where there's a difference in costs and things like that. And so we do advise clients to include in their agreement the idea that the client has the right, if they choose to have another attorney look at the agreement before they enter into it. I think we all understand from a practical perspective that consumer debtors don't do this, or if they do, it's at such a low percentage rate that it's almost not worth talking about. But I think it is important from a conflict perspective to let them know that. Okay, so we're going to move on to another major topic in the presentation, which is managing the internal flow. And again, as I said, Matt is really kind of the ninja at this, having run a high volume practice and kind of worked out the kinks here. So let's start talking about sort of the typical meetings and document flow in a bifurcated practice.
Yeah, well, first of all, let's talk about what I was called uniqueness of Chapter 7 clients. If any of you working with an outside marketing company, you got to make sure that those marketing companies understand how different a Chapter 7 consumer is from someone who's buying another service or product. And really, to me, what that means is that when Chapter 7 or potential Chapter 7 client is looking for an attorney, they are typically just at their wits' end. I mean, most of them sit and just sort of try to ignore their problems for, it could be years. But once they finally get ready to go, they are ready to go. And so, so in terms of like, nurture campaigns and different things that people use, they don't really work with these people. The most important thing is to talk to them as soon as possible. So, and that's just the whole intake call. You never want to miss a call, because if you don't answer the call, they're just going to call the next attorney. I mean, even if they leave you a message, or even if they fill out a form on your website, they're still anxious to get help, and they're going to just go on to the next law firm. So you just got to make sure you answer those calls, or they fill out a form, that you have a system in place where it notifies you and you call them or email them, immediately. Start answering their questions.
What we see and hear regularly too is that attorneys who adopt a post-petition payment term model, zero down or very low down for their clients, that messaging in that very first communication with the debtor, whether it's a digital communication through a pay-per-click campaign, and certainly on your first call, it's really important to make it clear to them that you have an option that doesn't involve them having to come up with a large sum of money up front. Yeah. Because that turns out, whether they tell you or not, to be the biggest reason that they don't talk to you, or that they walk out of a consultation without engaging you. It's about the money.
Yep. And then we talked a little bit about this, but so in a first consultation we have with your client, what we recommend is that you use a detailed client intake. Some attorneys feel like they're hesitant, or because people don't like to fill out these forms, but in reality, they will fill it out. Or they go to the doctor's office, or they come to your office, they're used to filling out forms. So have them come in and fill everything out when they come in. And your goal is to, of course, determine if they qualify for Chapter 7 and if it's in their best interest. But assuming you meet those two requirements, you're going to want them to sign the first agreement with you. It's not natural for attorneys to be salesmen, but you really need to put that hat on. And again, you're looking for your client's best interest, but assuming a Chapter 7 is in their best interest, then yeah, persuade them to sign an agreement and hire you so you can move forward and get them the protection with the automatic stay that they need.
Now, I want to emphasize here that while we talk about an intake questionnaire and a document list and things like that, those things don't exist in the vacuum. For you to do a good job in your consultation and your diligence, the intake questionnaire ends up being a framework for a discussion with the debtor. So, a lot of times, no matter how simply you try to phrase the questions and as much as you try to explain what it is that you're after, a lot of these debtors just won't understand that very well. And so there's no substitute for sitting down with them with the completed questionnaire and asking appropriate questions to get to the bottom of, what's actually going on in their life. Because as we've said before, the three things that you've got to make sure are that they're eligible for Chapter 7, that it's in their best interest to file or to file Chapter 7 as opposed to Chapter 13, let alone a Chapter 11 in rare circumstances. And you have to uncover whether there are those lurking landmines out there that would otherwise blow up without any advance warning after you filed the case, which it's happened to all of us at one point or another, with either a client who's not been honest or a client who's just forgotten something pretty serious. And you want to do everything you can to avoid that. Yeah, we've kind of talked about that already. So,
and we talked about this too. I mean, just again, even with collecting fees post-petition, doing 2 agreements, filing a skeleton or a rush case, you're still absolutely going to collect those documents and pull the credit report before you file the petition.
Okay, so now we've gotten to the point where you're filing the case. And we've already talked about the fact that you're going to file what we call a skeleton, rush, short, emergency petition. But instead of, the situation where it truly is an emergency and you don't have the ability to really uncover everything, you will have done your diligence here. So you're filing a short petition solely to provide the accommodation to the client of getting the case filed quickly and allowing them to make post-petition payment terms. But particularly where you're going to offer a zero-down solution to people, you want to do as little of the work, the filing work and the document preparation work as you can pre-petition.
Yep. And so in the filing fee, you do have some options with this as well. Usually the first option and best option, even though it doesn't happen all the time, is that to see if your client has the money to pay for the filing fee. Because even if you're doing a zero-down case, you can still have your client pay for the filing fee. Just make it clear in any advertising on your website that zero-down is for the attorney's fees, and they may be obligated to still pay out-of-pocket costs such as the filing fee or credit report fees, whatever else you might do. But so many people, when they come in your office, really don't have the ability to even pay the filing fee, let alone your entire fee before they start the case. So in those instances, you still have a couple options. One is you can put the client on or file an application for them to pay the filing fee installments. And I've done that. And the other option is just to go ahead, you as the attorney, include the filing fee in the total fees, pay that fee, and just include it in the post-petition payments that you're going to collect. And the latter is really the better option, just because it saves some of the administrative headache of having to deal with the application, to pay installments. Some jurisdictions call hearings to do that. It's just a lot of different things that can come up. But again, you can either have them pay it up front or include it in the financing terms.
Yeah, and the way to look at that latter option is the client is still paying the filing fee. They're just the first dollars that they're paying on that post-petition engagement are basically paying that filing fee, because there is some question out there about advancing costs, and that is a bit of a gray area.
Yeah, and also just to be clear too, I mean, until a filing fee is paid, a client can't pay you anything anyway. So, I mean, you can accept a payment from them and pay the filing fee, but again, really the best thing is to just get that filing fee paid and out of the way.
Yeah. All right, so kind of continuing on, now that you've gotten your case filed, there is typically a second meeting with the client that's needed to sign the post-petition engagement agreement. And I will tell you, some attorneys will actually have the client stick around in the office, particularly if they've traveled, to see you or something like that, while the case gets filed, and then they'll have them, there that same day sign the post-petition engagement agreement. What they typically can't do, though, is get the schedules and statements done same day. And so more often than not, attorneys will have the client come back for a second meeting that combines signing the engagement agreement for the post-petition work with reviewing and finalizing schedules and statements.
And another option too for signing that post-petition agreement, because some attorneys want to make sure that gets signed before they prepare the statements and schedules. For me, I always found it was easier. Just I knew they were going to come back. I knew they were going to sign up with us because they liked us. And so we prepared the statements and schedules. So when they came back, they would sign the post-petition fee agreement and the statements and schedules. But some attorneys want to make sure that post-petition fee agreement is signed. And one way there to avoid an extra meeting is to send out that fee agreement through a DocuSign or Adobe Sign, some kind of electronic sign, because they can sign the fee agreement electronically. Yeah. Obviously, statements and schedules, they have to review and have to put a wet signature on them. But the post-petition fee agreement doesn't fit in that requirement of a wet signature.
Yeah, a lot of the attorneys who are doing a very good job with client service but are still efficient, and that is a balance that you actually can strike, are using technology more and more to kind of tick off some of these boxes. We talked about retaining wet signatures.
I didn't want to talk about retaining. So you have to get the wet signatures, and this is typically a local rule. Usually it's in the ECF guidelines for the local area. But there are, the states actually vary quite a bit in terms of how long you have to hold those wet signatures. Sometimes it's tied to when the case closes, which honestly is kind of a nightmare to track what that is. It's how Arizona is. Others are just based on when you file the case or when the agreement was signed or the documents were signed. But just make sure you look at your local rules. And again, it's typically in the ECF guidelines where you'll find them.
And then, once you get past filing the schedules and statements, there is nothing different about a bifurcated Chapter 7 engagement than there is in a prepaid engagement. You complete the case in a normal manner, you show up for 341, you respond to trustee information requests, you deal with other issues that may come up in the case in the ordinary course of things. And in the meantime, your client, begins making payments to you or through us, if you're working with us, to help manage the payment flow. And in the vast majority of those cases, 90 to 120 days out, you'll get the notice of discharge, and pretty soon thereafter, you'll see the case closed, and there really is no difference from the time you file the schedules and statements moving forward. So let's talk a little bit about forms.
Yeah, we talked about this a couple times now, but to me, the intake questionnaire is very important. We talked about already that have your clients fill it out. And when they come in the door, the first thing you have them do is give them a clipboard and have them fill it out. As Dan noted, that's not the end of the intake questionnaire. The intake questionnaire to me is something you use as your guide for your initial consultation with your client. You have that form in front of you. You go through, you look for things they filled out, look for things they didn't fill out too, ask them about that. But it's really a good way to get lots of detail from your client that you need to make sure you're properly representing them and properly advising them.
And, we all know this. All of us who've done any consumer work understand that concepts like liens, secured financings versus unsecured, transfers, those are concepts that we understand very well as attorneys, but debtors don't. And so a lot of times too, even if you think you've gotten a consistent and complete answer to a question, you pause and you kind of explain something a little bit differently and make sure that you've gotten a complete and accurate answer to the question. But as Matt said, that intake questionnaire is important in its own right, but really should be a framework for a thorough consultation.
And we have a sample, again, that you guys can get from us. But keep in mind, one of the important things in the intake questionnaire is to deal with non-exempt assets. And so, if you use our form, make sure that you look at it in terms of what are the rules in your local jurisdiction for non-exempt assets, because you want to make sure you're identifying those. Next is required document list. Super simple, but boy, at the initial intake, if you sign the agreement, you have to give them a list of the documents you need, or you're never going to get the right documents back. Just have a basic piece of paper. It does seem to vary from district to district what people obtain, but at a minimum, you typically will get 2 years of tax returns and the bank statements and pay stubs. And then some jurisdictions go quite a bit further than that even. But make sure you give your people a good list so they know what to bring back to you. Talked already about the one-page options description, which again is something we'll give you, and that's the options of the pay before the case is filed, what the price is, or their options for financing it, what that looks like on a weekly, bi-weekly, monthly payment schedule. And of course, pre-petition engagement agreement, and the probably next is our post-petition engagement agreement, and we have those forms as well. And again, even if you don't use us, we're happy to share those with you because we want to raise the bar across the industry for everybody. We have very good disclosures in our agreements. We worked with a nationally recognized ethics council, and as well as just using our decades of experience with bankruptcy and input from others over the years as they looked at our forms and given us comments. So it's really pulls in information and people's thoughts on what a fee agreement should look like from a lot of different areas. I think they're very good.
So obviously you're going to want to include disclosure to your client about financing and payment management if it's applicable. So attorneys who work with us, we provide them with a debtor information sheet, and then there's a payment authorization form that clearly lets them know that you're working with us, that you're using some financing that we offer, and that you're going to have us operate as your agent to collect payments, which is all done electronically. So we make sure that you've got the tools in your hand so that you can disclose that adequately to the client so they know who we are and they know that we're going to be involved in helping you to collect your fees. And then, we've already touched on this a little bit too, and I've talked about the article and the forms and things. We've got very, very thorough court disclosures. And regardless of what software package you're using, these are easily adaptable in the templates that you have in your bankruptcy processing software. We're actually working with some of those companies right now to see if we can get some of our forms integrated into their document flows. But for now, it's very easy to take the disclosure language that we identify for Form B2030 and get that into your stock disclosure so that you don't run afoul of that very easily avoidable pitfall.
Yep.
Okay, so the last topic of the day before we take questions is just how to get started with this. And for those of you who are intrigued, but perhaps not completely convinced yet that this is an option that you want to pursue, we've got an interesting experiment for you. We've drafted an email that can go out under your signature that you would send to the last, however many clients you've had, say in the prior 30 days that you've consulted with and they haven't engaged you. That will basically ask them, if I had an option where you could make post-petition payments, would that be something that's interesting to you? We've used this with dozens of attorneys, probably closer to hundreds of attorneys now across the country. And we typically see about a 50% response rate from the folks who walked out of your office.
Which is really incredible when you think about it. So if, it varies greatly from attorney to attorney in terms of how many people have come to their office, but most attorneys only retain about half the people that come in their office. So the other half is still out there, and some have gone on to other attorneys, but the rest of them are still looking for an answer. So when you let them know the ability that you're no longer requiring a large payment up front, you're going to go ahead and get the case filed and let them make small payments for 12 months, the response is unbelievable. And Dan's right, it's generally 50% response rate from clients that you otherwise would have lost.
Yeah. So, in terms of getting started with us and getting onboarded, we provide a lot of support. We have a great client relations department, and we've developed a series of short but really effective videos to walk you through exactly how you incorporate this practice into your firm. We have a program called Lunch and Learn. When you onboard with us, we'll actually buy lunch for you and your entire office, have you guys sit down and watch our training videos. It's a series of 9 videos. They're anywhere from 3 to 5 minutes a piece, so it takes about 45 minutes in total. And then we do a live Q&A over the phone or over Zoom with you to answer any questions that you might have as you're coming on board. But we found that that's a really powerful way of kind of getting, necessary changes to your documents and your flow in place, in kind of a spoon-fed fashion.
Yeah, and really we offer more than just the basic services that we offer in connection with post-petition payment terms. We also just help our attorneys with their practices, just whether it's marketing, which we're going to talk about in a second, or if it's flow, documents, whatever it is. We really try to help every attorney that we can in all ways, and we have a lot of expertise in-house here at Fresh Start Funding.
Yeah, so we don't really talk about this in this particular webinar, but we also back up what we do with a defense guarantee and an indemnity. So attorneys who come to work with us and adopt zero or low down terms for their clients, if they get unwanted attention, questions from judges, trustees, we will actually help in drafting responses informally. We'll certainly draft briefs for you if a motion gets filed. And I am quite literally jumping on an airplane, not infrequently now, to show up at hearings, to answer questions from judges and to do oral argument on motions and things like that. So we stand very much behind you. And then in the unlikely event that we got a bad outcome and some fees had to get disgorged, as long as you followed our processes and used our forms, we provide you with an indemnity up to $50,000 for fees that you might have to cough back up.
I do want to note this never actually happened.
Yeah, it actually hasn't. We've been getting very good results, and we're happy to say that the acceptance of this practice across the country is definitely growing.
Yeah.
So the last topic is marketing, and we really haven't touched on this much, but there's something powerful to say about that too.
Yeah. So again, I talked a little bit earlier about how potential Chapter 7 clients are very unique, at least compared to other buyers of services and products. And so we have, I have all what I learned in my practice. We offer this information to you. So we have a training video that is me talking about the things I learned. We have a sample landing page you can use to drive traffic to. We have sample Google ads. If you're new to Google and not really sure how to phrase ads, we have ones that are very effective for people. And we also have people we can refer you to. I know in my practice, I basically wasted money on some marketing companies, and I really didn't get results out of them. And I hear that all the time from people. But that being said, we actually do know a couple marketing companies that have done a great job for our clients. And we have no financial connection to them whatsoever. But we're happy to share their names, and you can talk to them and decide if they're a good fit with you or not. But again, we want to help all the attorneys grow their practice and help more debtors.
Yeah, we haven't talked about this again as much in this webinar, but our corporate mission, even though we work directly with attorneys, focuses on debtors. It's about making a fresh start affordable and accessible to everyone. Mm-hmm. And really what offering post-petition payment terms does is it kind of ticks off the box of giving you an opportunity to do well by doing good. It's the classic win-win that helps debtors access the system with the benefit of counsel. It lessens the burden of pro se debtors on the courts and their staff, and gives you an opportunity to grow your practice by doing the right thing and helping more people. Mm-hmm. So we've got a couple of questions. It looks like Jim wants to know, have y'all worked with Best Case software? And the answer is yes. In fact, we were just talking to George, who's the attorney consultant for Best Case the other day in Detroit, and we've got another conversation set up to see if we can't get some of our forms integrated directly into their platform. But for now, what we have is the ability to kind of help you get the language that's in our Form B2030 integrated into their form, so that you can simply do it one time, and then in any of your cases where you offer post-petition payment terms, you got the form in there. Yeah,
and the short version answer, which seems to be the same in all the software. Again, Best Case actually told us, I think they represent more than 80% of the market.
85.
85% of the market of people who are represented by attorneys use Best Case. But what you do in Best Case and Next Chapter and Send Compass is you basically there's what they call a template in there already. And sometimes it's a local jurisdictional template, or a lot of states just use the national one, the form B2030. But you take that form, you create a copy of it in the software, and then you make the changes to the copy. And then for the clients who pay up front, you'll have the standard version. And then for the ones who you're doing post-petition payments on, you'll have the modified version.
Yeah, and actually, I think that addresses the second question that Roger asked, which is whether we've got the forms automated. And so I will tell you, we're constantly working to make this even more streamlined for you all. But it is very easy to do, and we can kind of walk you through that process so that you don't have to do a custom form every time you file one of these cases. Because as we know, efficiency in this practice is everything.
Yep.
Okay, so I think that handled the questions. So Matt, you want to talk about how folks can take the next step with this?
Yeah, it's really easy. So all you have to do really is pick up the phone and call us. And we have a very educated and smart staff who know what they're doing. We're working with literally hundreds of law firms across the country at this point. I've lost track of how many states we're in. I think last I heard was like 46 or something.
46, I think, yeah.
And so, I mean, there's lots and lots of attorneys out there doing this. And so just give us a call and we'll help you. We'll answer your questions. We'll get the documents to you. As we talked about, we'll do the training for you and your staff through our lunch and learns. And then we even do we have a QC, quality control program, after you file to make sure you stay on track and doing things correctly. But the way you do that is you can call us at 800-915-6545. Again, it's 800-915-6545. You can also go to our website, which is simply freshstartfunding.com. So either way, you can reach out to us and we'll be happy to get you going.
Thanks so much for your time today. I hope this has been helpful to you. We certainly enjoy talking to attorneys across the country about this opportunity and look forward to helping you grow your practice by helping more people.
Thank you.